Valerie. I'm a research fellow at the NEXA Center of the University of Turin in Italy. And I'm also a data protection officer within the Fiat Chrysler Automobiles group in the financial sector. And I'm very glad to chair this session about one core question, one core argument in the data protection field and data protection landscape. Let me just set the stage of our discussion, because I really believe that this discussion is core to all the ongoing panel that we are facing and we are listening these days. The core question, the core point here is private law liability. What do we mean and what do we not mean when we talk about private law liability? And we talk about something that acts in an ex post moment in order to rebalance cost of data protection, cost of harmful situations that were generated from processing operation that was put in place by different actors in the chain of processing, personal data processing. The point we are going to discuss is not related to all the other mechanisms that a data subject has in order to, let's say, act and reinforce and enforce his rights. For example, we're not talking about criminal tools that our society has to prevent other kind of situation. We are not talking of the action of data protection authorities and or the other new remedies that GDPR is putting in place. For setting the stage, another point that I would like to start with is from a concrete example. Because I think that this will surely lead us to understand better where we are now and what we are talking about. And the example is the well-known Ashley Madison data breach case that occurred a couple of years ago. Ashley Madison is a dating platform that was breached by a group of hackers that wanted to criticize the business of the company and to increase transparency on data deletion policies that the company was putting in place for 19 euros to be paid by data subject. This group of hackers stole and publicly released 300 gigabytes of data of lots of millions of people. And as you can understand, a lot of harmful situations were generated. And the different kind of, let's say, causalities that happen after this data breach is very diverse. We faced a situation where people, friendship and marriages get broke. We saw a situation where other kind of relationship get broke, so like working relationship, but even other kind of more immaterial situation where came out from this situation. Like, for example, feelings, immaterial, let's say, consequences, like, for example, a situation of embarrassment, anxiety of data subject who were just feeling insecure after this breach occurred. So, as you can see, different shades of effect, different shades of harm or of possible damages were generated from this fact. So the main question that we are going to start with today is about what we have to consider as a harmful situation. And I personally believe that for talking about this point, we shall start from what we understand as risk. Risk is another core concept in all the ongoing GDPR discussion, privacy and data protection discussion. Me personally, researching and working within a very industrial context, I am experiencing different kind of risk. And the difference that I'm understanding while putting in place, let's say, data protection management tool is how to assess the risk in front of a data subject, with having regard of the data subject, having regard to rights and freedom of the data subject. This is the main question. This is the main change, because usually companies are very used to assess risk with regard not to data subject, but to their own business, from external factor to their internal situation. Nowadays, the game is totally changed. It's oppositely changed. The companies, organizations in general are going to assess risk from inside to outside, and this is, I guess, the main change. So starting from this, we can surely understand how different harmful situation could be prevented and which measures should have to be put in place in order to minimize the risk. The core question is when something happened, when one of these risks actually transformed in something that is actionable, that caused a harmful situation, where do we have to put the threshold? Where can we set the stage, set the level for understanding what is worthy to recompensate under a private law liability and what is not? And this is a very vogue question, vogue area that team Walree from Radboud University will start working and talking with. Lot of other questions will come out when we start thinking about the different people and actors who will work in the chain of processing, because as I said, I'm going to understand risk in different situations. And one of this is how to consider external processing operation software provider, and this will be the core argument that Pieter Wolters from Radboud University will shed light on. Another very important issue is the role of the data subject that will act and will start working in order to be a political subject in this point. And this will introduced by Claudia Quelle from Tilburg University. At the end, a very important topic that I'm personally also working on is about ethics. So we are working to get compliant. I am personally in a rushing moment, in a hurry moment for being compliant with this tool and understanding all the risk I'm facing. But the point is how to move from a culture of simply being compliant, to a culture of caring. And this will be issued by our colleague Valerie Lyons from BH Consulting. My greatest pleasure is to be here beside Mireille, professor of VUB Universiteit here in Brussels, and that is our moderator, and to whom I will leave the floor. One last point is about question. I'm sure a lot of questions will come out from our discussion, so please note them down, and we will do our best to take the last 15 minutes for all the points that will come out. So thank you, and Mireille, the stage is yours.
Thank you very much. And since you've already, I wanted to introduce everybody, but you've actually already done that in a very nice way. That means I'm going to immediately give the floor to Tim Walree, who is a PhD student at Radboud University. Please, are you going to stand up here, or you're standing
Yeah,
here?
no, I will just sit down, I guess.
Okay.
So thanks for the introduction. I will tell something about the problem of the absence, or to be more precise, the problem of the absence of legally relevant damage if there is a violation of data protection legislation. And in essence, I will argue that the high threshold for immaterial damage is a barrier for an effective enforcement of data protection legislation. And I will explain this on the basis of the following example. I hope that it works. Yeah. Imagine that your bank states in its privacy policy that it won't transfer your personal data to third parties. However, despite its promise, the bank sells your personal data to an advertiser. As a customer or as a data subject, you are frustrated and you decide that you want to take action towards the bank and you want compensation for the unlawful conduct, in this case, the illegal data transfer to the advertiser. And as a data subject, you can initiate enforcement via two routes: the public route or the civil or the private law route. And through the public route, you have to go. The public route means you have to go to the Data Protection Authority, and you can file a complaint because you are of the opinion that the bank processed your data unlawfully. If you go to the DPA will assess your complaint and then decide whether or not it will process your complaint. However, enforcement via the DPA has its limitations. Firstly, there's the budgetary constraint. This means, for example, Netherlands, the DPA, the Dutch DPA, only has half the budget it needs to function accordingly. Secondly, investigation takes lots of time and effort. This means that the DPA cannot process all individual complaints. And thirdly, and this argument is the most relevant for my talk, the DPA cannot grant compensation to a data subject. So if you want compensation because you are frustrated or you think you have material damage because of the unlawful data transfer, you have to go to a civil judge. And you have to litigate via, with the help of civil law. And if you go to the civil judge, you have to prove before the civil judge that you have suffered actual and certain damage that is legally relevant. But if we look to the example I just mentioned, the bank example, one may ask, what's the damage here? Is the unlawful data transfer of the bank, does it constitute material damage? And is the frustration that you as a customer can feel towards your bank, is this enough for compensation of immaterial harm? In other words, is this legally relevant damage that needs to be compensated? Before I will answer these questions, I will first explain the notion of damage according to Dutch liability law. So what constitutes damage according to Dutch liability law? Roughly there you can divide damage between material or immaterial damage. And material damage can be best described as a loss that you can feel in your wallet or assets, such as a loss of income, a loss of profits, or a damaged asset, such as a damaged car. Immaterial damage is something else, of course. And as I said at the beginning of my speech, there's a high threshold for acknowledging immaterial damage. And in my opinion, this high threshold is a problem, as in most cases of data protection violations, there are those violations are not, in most cases, not felt in someone's wallet or assets, but rather have an immaterial impact. That means that there is an invasion of someone's moral autonomy or human dignity, or are not particularized or do not have a specific impact on an individual, or have more an impact on collective or societal interests. So as I said, the threshold for immaterial damage is high. So let's get back to the example. Let's see if it works. So if we look back to the example of the bank, is there material damage that is eligible for compensation? If we look to the specific circumstances, it's very hard to observe any material damage. And in my opinion, even if we could quantify this amount of damage, it wouldn't be rational for a data subject to start a civil procedure. After all, litigation is costly and can take long. And compensation must outweigh the cost of the procedure. If not, it wouldn't be rational for a data subject to start a procedure. So with regard to this case, I don't think it's likely that a data subject will get compensation or will start a procedure to get compensation from the bank. If we then look to the material damage, is there any material damage that is eligible for compensation with regard to the bank example? In the Netherlands, we have two general categories of material damage that are eligible for compensation. The first one is the mental injury. And mental injury means that the victim, in this case the data subject or the customer of the bank, needs to prove that he suffered or encountered psychological damage as a result or as a consequence of the illegal data transfer. And I think it's very unlikely that a Dutch civil judge will grant such an appeal. If we look to the other category of immaterial harm that is eligible for compensation, this is something that is called integrity damage, or is called integrity damage in literature, and is also recognized in case law of the Dutch Supreme Court. I think this is a more viable option. Integrity damage does not require a mental injury, but what it does require is a severe violation of a fundamental right with extraordinary effects for the victim. And what we see in Dutch case law is that an appeal on integrity damage or integrity damage is only acknowledged in exceptional circumstances. And if we apply integrity damage, or if we want to see if there's any integrity damage in the example of the bank, I think that, again, a civil judge won't grant this appeal, because if we look to the example of the bank, yes, there is a severe violation of a fundamental right, in this case, the right of data protection. To be more specific, there's a breach of the purpose limitation principle. But again, or the effects of the customer or the data subject is frustrated, but these circumstances are not exceptional enough to acknowledge integrity damage, in my view. So again, compensation of immaterial damage is not likely.
1 minute.
Yeah. So this all leads to the, this means that the data subject does not have, because he cannot suffer, because he cannot demonstrate that he suffered concrete damage, he does not have a leg to stand on, and this means that he cannot compensation, and that he cannot effectuate or his data protection rights effectively, at least from a civil perspective. It also means that there misses a strong incentive for a data controller to comply or to adhere to data protection legislation. And this all leads to the odd conclusion that a data controller or processor can breach a rule of data protection law with relative impunity unless the data subject suffers severe damage. And what we see here is a conflict between, on the one hand, the requirements of liability law that require concrete, quantifiable, and observable damage, and on the other hand, the more immaterial impact of a violation of data protection legislation, which is, as I said, which rather invades someone's human dignity or more autonomy, or not particularized or not specific for an individual. And in my view, as long as we don't resolve this conflict, I don't think we can speak of an effective enforcement of data protection legislation, at least from a civil perspective. That's it.
Okay, thank you very much. I think that was a very clear explanation of the problem, the basic problem, the first problem that you run into when you try to get civil law liability, tort law liability, as a actionable, effective and practical legal remedy for data protection harm. I'm going to do, after every presentation, a very quick question, and we'll have the rest of the conversation and discussion after everybody has spoken. My very quick question to you, Tim, is when I listen to you, I'm not sure in the end what is your point. Do you think that Article 82 of the GDPR that requires this to be an effective legal remedy if there is damage, are you saying that we should enable within private law compensation when damage is actually either hypothetical or difficult to individualize?
Yeah, that's a good question.
Very quickly.
To be honest, I don't know. What I do know is that Article 82 opens up the possibility for the European Court of Justice to broaden the notion of damage. If we look to Recital 146 of the GDPR, we see that the ECJ has the possibility to interpret the notion of damage broadly in the light of the objectives of the regulation. But to get back to your question, I think that we have to prevent that on the one hand we don't want we want a more effective enforcement for the data subject, but on the other for the data subject. But on the other hand, we don't want that the data controller has to pay for damage that has not occurred. So it's very, very hard to balance those two interests. But to be honest, I don't have a concrete idea how to fill those how to fill this in. And I have one general idea, and that's what I heard a couple of times these days or yesterday in 2 other panels, is that there can be fixed damages for violations, but I don't know if this is the perfect remedy.
Okay, that's an interesting position. So, Pieter Wolters, can you take the floor?
Yes, I'll stand.
Yes. Pieter Wolters is assistant professor, researcher at the Business and Law Research Center of Radboud University, studied law at Radboud, the University of North Carolina and University of Michigan, completed his PhD in 2013 on the factors that affect the requirement of good faith and fair dealing in private law, and now working particularly also on cybersecurity and private law. Please.
Thank you. So today I'm going to talk about who might be a source of risk. Yeah, sorry. And let's start with my central position. The GDPR is designed to apply to all matters concerning the protection of personal data. So all matters concerning the protection of personal data, as stated by recital 173. But I will argue that this goal is not met. In particular, this goal is not met when we look at the security of personal data. In many instances, the security of personal data depends on different actors. And not all of these actors will have a security obligation under the GDPR. Furthermore, a data subject may not have a right of recourse against these responsible actors. So if a data breach is caused by inadequate security, a data breach may not have a remedy against the responsible actor. So I will illustrate this with a case. A company processes the personal data of its customers. It hires a call center to provide customer support. And this personal data is, of course, shared with this call center. Furthermore, it secures the data by hiring a security specialist and by buying a firewall that is provided by a third party. So that gives us this case. So each of these parties is a source of risk. The personal data of the customers could be breached because the call center or the company is careless, but also because the firewall does not function properly or the IT security firm has not provided good security to the company. If the GDPR is to apply to all matters concerning the protection and thus the security of personal data, all of these actors should have a security obligation. So for the company, this is straightforward. The company is the controller of personal data, and thus it is governed by Article 32 of the GDPR. A controller is obligated to take appropriate technical and organizational measures to secure the personal data. In principle, this is the same for the call center. The call center is a processor. It processes the personal data on behalf of the company, and so it is also bound by Article 32, because Article 32 also applies to processors of personal data. Note, though, that this was different under the Data Protection Directive. Under the directive, only the controller had security obligations. The directive did not directly impose a security obligation on the processor. And I'm saying directly. Why? This is because the controller did have an obligation to only use processors that provide sufficient guarantees in regards to the security of personal data. And furthermore, the controller is obligated to enter into a contract with the processors stipulating that they are to take security measures. So the end result should be the same. The processor will have a duty to secure personal data. Still, there is an important difference between the GDPR and the directive. Under the directive, the existence and the scope of the security duty ultimately depends on the contract between the controller and the processor. So if the controller fails to contract with the processor or does not contract directly, the processor will not have any security obligations. Furthermore, this is a contract. It needs to be interpreted, and this is a matter of national and not EU law. And even more important, the data subject would not have a right to compensation from the processor. It is a contractual duty between the processor and the controller. The processor has a security obligation, but it is only owed towards the controller. The data subject cannot get any rights from this contract. At least in principle, this might be different depending on the national law of the member states. But again, this is a national law issue. So this is an important difference. Under the GDPR, the data subjects have a right of recourse against both the processor and the controller. The processor has a security obligation towards the data subjects, even if there is no contract with the company. Under the Data Protection Directive, the data subjects can only claim compensation from the controller. So, this is a crucial point. The GDPR extends the protection of the data subjects by extending the security obligations to the processor, to other parties than just the controller. But the processor is just one of the other parties that is responsible for the protection and the security of personal data. In our case, the firewall and the IT security specialist also play an important role with the security of the personal data. However, they may only provide software or provide services to the company, and they do not process any personal data themselves. The GDPR does not impose security obligations on actors that do not process personal data. It does not impose any obligations on actors that do not process personal data. The GDPR does not explicitly impose an obligation to enter into a contract with these other actors. Now remember the case with the processor. The controller had to enter into a contract with the processor stipulating that there is to be security measures. No such explicit obligation exists under the GDPR. However, we could interpret the articles 5.1f, 24 and 25 to impose such an obligation. Security of personal data is one of the principles of the GDPR, and a controller is to take appropriate measures to ensure these principles, and forming a contract with a firewall or an IT security specialist stipulating that security can be expected should be one of the measures that a controller should take. But even then, this would only bring us back to the situation that exists under the Data Protection Directive with regards to the processors. The security firm and the developer of the firewall only have a contractual duty towards the controller. They do not have a duty towards the data subjects, and the data subjects have no European rights to damages or any other recourse against the security firm and the developer of the firewall. So, what should be the solution? Crucial in the GDPR is that it improves the position of the data subjects by extending the existence of security obligations and liability to the processors. And I think this trend could be continued. Although the requirements will need to be fleshed out with great care, future European rules could create security obligations for other actors that are responsible for the protection of the personal data, even if they are not processors themselves. So I've given security of personal data as an example, but I think this could also apply to other aspects of data protection. Why should data protection only be an issue for parties that possess personal data themselves and not for other actors that are important for the protection of personal data? So thank you for your attention.
Thank you very much. I think that was again very interesting, to the point and precise analysis of a very important third party that seems to fall outside the protection against security breaches or unlawful processing. My question to Pieter is, Article 10 of the draft e-privacy regulation looks precisely into this by having a direct obligation to software developers. Let's assume that a direct obligation, however formulated, is going to be part of the final version of the privacy regulation. Do you think that that is enough to fill the gap that you notice, or do you think, because of the limitations of the privacy regulation, that a similar direct obligation should have been part of the GDPR?
I think that the e-privacy regulation, is a big step forward and a big step in the right direction. But as you said, it has several limitations. It only applies to electronic communications. And furthermore, it imposes direct obligations on software providers, but on software that is used for the electronic communications. But as of now, this is only an obligation to provide privacy-friendly settings. There is no security obligation imposed on the software providers as of now. So yes, I do think it is an important step forward, but it is also a very narrow one. So in regards to your second question, should it be included in the GDPR? I think so. I think that the GDPR has shown, has taken the right path by extending data protection obligations to other parties than just the controllers, only to the processors, but why not to other actors? Like I said before, formulating the obligations as they should be precisely is a hard task, but I don't think it is impossible. One more thing is that the Digital Content Directive proposal also creates security obligations for software providers. As the proposal stands today, they are kind of soft, so I don't think it is a solution, but it also shows that we can take steps to better the situation.
Thank you very much. So now we have heard that the damage is a big problem, is a hurdle. We've heard that the liability of certain third parties are a hurdle. We've heard all sorts of reasons why private law liability is not going to be the panacea for data protection, and I think that Claudia Quelle is now going to explain to us why that may be the case and where we're going to be saved. So she's a PhD researcher at Tilburg University, Tilburg Institute for Law, Technology and Society, TILT. She graduated from Utrecht Law School and Tilburg Law School with the highest distinctions. And her research project examines the risk-based approach to data protection law in relation to fundamental rights.
Thank you, Mireille. So, yeah, my research project is normally about the risk-based approach, but I was very happy to step in this panel as a last-minute replacement speaker, because in thinking about the risk-based approach, I've also been thinking about what it means that the GDPR is a fundamental rights instrument, whilst at the same time interfacing with private law. So I thought today I would speak about compensation for societal harms. I think one of the questions of this panel today is whether the GDPR can address, can have private enforcement through compensation. So we've been focusing on compensation as an aspect of enforcement. And of course there are other ways to enforce laws. And in thinking about this question, I think we should make a distinction between violations of our rights and freedoms on the one hand, which often result only in societal harms or collective harms, and on the other hand also harms to individual interests. Because of course the GDPR protects against both types of harms. I think Pieter was right to emphasize that there is also a clear private law aspect there, that security, for example, is a clear problem that we should address. But I'll focus on the fundamental rights aspect today. So for me, the GDPR mainly concerns fundamental rights. I think you can see that in Article 1, which spells out the objective of the GDPR. And I think this is strengthened by the risk-based approach. If you look at Article 24, the controller has a clear responsibility to take into account our rights and freedoms. Article 35 stretches that further by specifying that there should be a data protection impact assessment in which the risks to those rights and freedoms have to be assessed. So what does this mean that the controller has this general duty? Well, it's a duty that is owed with respect to all data subjects. All fundamental rights, all rights and freedoms of data subjects have to be respected at the general level. And that is suitable to be able to address these societal issues. Think, for example, about surveillance. Surveillance is clearly a privacy issue. And it's a privacy issue in part because it causes chilling effects that we are worried about on a societal level, a collective scale. And what I mean to say there is that it cannot be felt in the same way at the individual level. US courts have been trying to understand how surveillance can cause individual harms, leading to absurd consequences. One US court even ruled, for example, that, well, surveillance being tracked on your cell phone is a problem because it drains your battery. Right? I mean, obviously, that's not what we're really concerned about. And even if you look at the anxiety caused at an individual level, there is simply something about surveillance that is problematic at a scale, even you don't know it, even if you add up, even if you take the aggregate of those individual damages, you don't get there. That's what it means that a harm is collective or societal. But the interesting thing about the GDPR is that it's not just about the general protection for fundamental rights. It is also about bilateral relationships. We have subjective rights as data subjects, which also mean that we have a level of choice, an element of choice. And you can see this because who is the one to consent to a data processing operation? It's the individual data subject. Who has the right to rectify information or to object? The individual data subject. So even if the controller is under this general obligation with respect to all rights and freedoms of all data subjects, there is also a bilateral relationship between the controller and that individual. And take that, as well as the fact that data protection law applies between private entities, and we are faced with the question, how does this relate to private law? There is an interface. And so private law can be used in situations also to address problems. So I've been thinking about how this fundamental rights aspect translates into things that we usually consider to be a private law kind of thing. So I've been thinking, for example, about consent and the rights of data subjects in Chapter 3. How do they make sense given their fundamental rights nature? And I would say here that we can make sense of it. And I've proposed to see it as a sort of a political right. Because what's happening here is that the controller has that general level of protection, and it's supposed to be a good level for all data subjects. And then you can say as an individual, well, I'd rather see my rights and freedoms protected in a slightly different way. So it's a right not to be misrepresented. It's a right to have a voice what your rights and freedoms means. So in this way, I would propose that we can make sense of consent and our rights under Chapter 3. But can we make sense of compensation in a similar way? Can we translate this private law form to make sense in this context? And I think that's more difficult, as we've already seen as well today. Because what a data subject is doing when she's claiming compensation is she's going to court and saying, I've suffered a harm. In my relationship to the controller, I've had a setback. And that should be rectified. Compensation is corrective in the sense that the injustice between the controller and the data subject should be rectified or corrected. And what I just noted about societal harm or individual harms is that they're different from societal harms because societal harms cannot be felt at the individual level. So what can you claim as an individual data subject? That's precisely the issue that we've been discussing today. It's very difficult to make that jump. What we can do with societal harm is we can enforce it and we can punish controllers when they don't do it right. And typically those tasks have been carried out by our supervisory authorities. And what we're seeing now is that maybe we also want private actors to fulfill that role. And this is where I am optimistic about collective injunctions. But if we want compensation for societal harms, I say, well, what we're actually talking about is punishment, not correction. So that was it. Thank you. I've based it on a paper I'm discussing at PLSC. If you're there today, please stop by.
Thank you very much. This raises again a whole series of questions, so let me restrict myself now to one. Question for clarification. So in my mind, fundamental rights are individual rights. So an individual can enforce them against a government, sometimes against more than a government, depending. You seem to suggest that fundamental rights are only about societal goods, and I heard you even say that individual subjects don't experience the violation of that right. I totally agree that fundamental rights protect a collective good, a public good, but that for me that is not exclusive, not mutually exclusive with the fact that it's an individual right. And I would feel very sorry for our society if it stops being an individual, a subjective right. Maybe a short response to that?
Yes, I fully agree that violations of our fundamental rights can also be felt at the individual level. So if you're discriminated, for example, you can suffer clear material and immaterial harm if your employer fires you, for example. But what I'm trying to say is that we value fundamental rights not only because the aggregate sum of those individual harms. They're more important than that. And so we can have individual compensation, but it will never fully do justice to the right.
Okay, we're going to move on to Valerie Lyons. You're going to stand up also? Okay. So Valerie Lyons is Chief Operations Officer at BH Consulting. She was Head of Information Security at KBC Bank Ireland for more than 14 years. And one of the first women in Ireland to hold the CISSP qualification. I looked that up. That's the Certified Information Security Professionals qualification. Currently, she's studying for a PhD in information privacy. The floor is yours.
Thank you very much. So as you can hear, this is working. Yeah. As you can hear, I'm not a legal person. I'm a practitioner who's undertaken a PhD. So I'm just a lowly practitioner. So what I bring is the research that I'm undertaking really with my current PhD. What I'm talking about is doing privacy right as opposed to just doing privacy rights. And it would probably be better called doing privacy like the Tour de France. And the reason is that in the Tour de France, as we all know, there's been stories of drugs over the years, and we've come to a place where we actually think they're all doing it. And so in order for that to change, they've had to instigate continuous audits on blood tests, etc., during Tour de France cycles, and that gives us, as the consumer, a sense of trust, a trust and belief in our cyclists. So it's exactly the same perspective that I'm taking now with organizations and information privacy. We all know they're doing it. We all know they're doing wrong with our data. We only find out, similar to the cyclists, when there's a data breach. And that's when we find out, and therein lies a problem, in my view. It's very slow. Do I point it in a particular way? Aha. So what I'm going to be covering are the challenges currently with private law liability and data breaches, and these thresholds that we've been talking about, and how important these thresholds could be. The threshold in public law, in GDPR at the moment, are significant, and those thresholds can act as a deterrent. But what about in private law? So privacy is currently being discussed as a legal framework, but it's also got an ethical framework, and it's bringing that ethical framework into our perspective that I think is going to be the most important going forward. And then CSR. CSR, as you know, corporate social responsibility, is where I see the future. Some people see CSR as organizations claiming they found Jesus, but you know, it depends on your perspective. So challenges currently. The burden of proof currently on the data subject is onerous. Now in the GDPR we know that the burden of proof falls back to the organisation, but typically, let's be honest, the data breaches that we've talked about, how far does a breach have to go before a data subject will actually take action? And that call to action is the most important element. I've had numerous situations over the last 10 years where I feel my data has been misused, or I haven't had proper ability to have transparency or consent or choice, or to be able to actually disconnect from, say, a continuous set of emails. But what do? Nothing. And an awful lot of people do exactly the same. It's the call to action that must be quite significant before a data subject actually does something. Threshold issues, which we've spoken about already, I'm just going to quickly go through them. There has to be injury, okay? It has to be cognizable injury. And that's very, very difficult to prove when the injury may not be now. My worry, my anxiety may be that my identity has been stolen and it may be misused in the future. and that's the increased risk of future harms. And currently that's been insufficient to state a claim. This current, the number of courts that have actually dealt with this situation and come out and said, no, it's a speculative risk, it's a risk in the future. In the Equifax breach, many of you may know the Equifax breach. In the Equifax breach, the problem that the data subject experienced was that speculative risk. What's my data going to be used for in the future? And what Equifax did, which is the unethical component as opposed to the legal breach, was they offered their customers, which was really nice of them, the opportunity to purchase insurance against future risk. And of course, they were the beneficiaries of that insurance policy. But also the courts have said that cost is not one because it's based on speculative risk, so it's not one that they're going to cover. So you can have insurance to cover identity theft in the future, but they're not going to cover that as a damage. Okay, and then the big one, which is emotional injury, stress, anxiety, that may result from loss of privacy. And again, we've spoke about emotional injury. However, privacy is affected by so many different things. Privacy is affected by your age, by your gender, by your culture, by your law and your nation. And it's got so many different mediating factors, but one of the most important ones is your propensity towards privacy. Now, what propensity towards privacy translates into is I may be a more private person than Mireille, or maybe Tim is more private than me. So the same incident can have a dramatic impact on me, but may not have such a huge impact emotionally on Tim. And how do the courts account for that? So they're the threshold issues, but the most important thing is that discovery for the data subject to take action relies entirely on disclosure or an actual detection. Okay, so a breach must occur. Something must happen in order for the data subject to take action. And the problem is, back to the Tour de France, we know what's going on, we just can't get a window inside the organization to actually see what's going on. And that is, for instance, the example I give here is Facebook and WhatsApp. I don't know if any of you know, but my children have told me that Facebook is for oldies. And Facebook also know that Facebook is for oldies because Instagram and Snapchat for youngies has all the mobile data, and Facebook are missing mobile data. And that's why they have spent billions buying WhatsApp. Billions, not millions, billions buying WhatsApp because they want the mobile data that they can't get in Facebook because the oldies are using their laptops and they're not using their mobile phones for Facebook. Now, I'm on both Facebook, because I'm an oldie, and WhatsApp, okay, because I'm trying to be a youngie. But the two things together have had absolutely no impact on me, but my data is being used by Facebook for what I don't know, but I have no window until they have a breach. When they have a breach, then I'm going to find out what they're using my data for, but that's the only way I have of finding out what they're using my data for. Okay, so this is my view. And very, very quickly, I have 8 minutes to speak. I'm Irish, so please bear in mind that's a real, real achievement. 1 more minute. 1 more minute to speak. So CSR as an ethical component, the stakeholders, we've got a number of different environments. CSR is corporate social responsibility. It sits in the middle. It connects it all together, ethical and legal. Mireille, the European Data Protection Supervisor, too, believes that simple compliance to regulation will no longer suffice and that we must look at the ethical component. This is a list of CSR reports. You can see here that Yahoo, Facebook, and Amazon don't have any CSR reports. That just might tell you something because the CSR gives us a window into what an organization is actually undertaking at the moment in terms of their privacy initiatives. Privacy is in a number of different organizations in terms of their CSR reportings. The reason is that it's now mandated by certain CSR reporting standards. So 5 years ago, when the same study was undertaken by somebody else, they didn't get the wealth of data that I was able to get. 19 out of 24 reports, these are the technology companies, Fortune 500 thought leaders. So 19 out of 24 of them reported privacy as a key concern. Only 5 companies reported privacy in a way that goes beyond regulation, okay? And they were Dell, Cisco, IBM, Apple, and HP. You'd kind of guess that they were the types of organizations. This is to give you an idea. They all produce material assessments in their CSO reports. This is eBay's and Rank Xerox. You can see top right-hand corner in both cases, security and privacy are number 1. And that's the same for all of them. These are just some of the things that these organizations have said. Dell is committed to responsible and transparent way to ensure customers, employees, and other stakeholders are represented at all levels. I beg your pardon.
That is self-regulation.
That is. That's my 8 minutes up, but I'll just quickly finish off. Cisco here, the most important ones. We're going beyond traditional privacy policies and practices. IBM employs some of the most sophisticated enterprise-level security. It should. It's got Watson. It has no way to sell it unless it does that. And Apple doesn't implement privacy because law tells it to. It implements it because our commitment to protecting your privacy comes from a deep respect for your data. Okay? So, quickly, beg your pardon. If organization were to implement a culture of caring, they wouldn't act, and this is what a culture of caring is implementing privacy in such a way so you engage with the trust relationship, they actually will have less privacy incidents. And that's where I want to try to see organizations go to, is having less privacy incidents as opposed to waiting on the damage to occur. Thank you.
Thank you very much. I think that was very interesting, especially also the technologies of the self, as the Foucauldians amongst us will understand what I refer to. So one of the things that you said I found extremely interesting, that the start of especially private law liability case law, so going to court and actually trying to get your right operational, actionable, that sort of seems to depend on breaches. And before a breach comes out, there's a whole process. The question is whether it will come out. And once it's come out, you're saying that this is not just a matter of substantive private law, so what is considered to be a harm that is protected by private law, identifiable as an individual harm, quantifiable. But it's also a matter of being fully dependent on discovery, because the burden of proof on the individual is very difficult to realize. And that discovery, we're talking Anglo-American evidence law now, is then dependent on disclosure. So the whole incentive structure, even after substantive law would have done its work, is very problematic. Actually, I do not have a direct question to you. And what I would like to do now before, I have many more questions, but I would like to go to the audience first, because you've been very patient with us. Is there a question now in the audience? Yes. Glory.
Hello.
Gloria.
Good morning, everybody. I have actually 2 little questions. So I'm Gloria González-Fusten from the Free University of Brussels, and I'm very, very happy with this panel. It was very interesting. The first question is more or less a common question for Claudia. I was a bit surprised that you didn't mention what for me is the basic paradox of this discussion of harm. When we look at the fundamental right to data protection, it is not about harm. It's not about societal or individual harm. It's not about harm at all. This has been explained by the court in Luxembourg. There can be a violation of the fundamental right, and we don't care whether it was a harm for the individual or not. And then for me, that's important when we try to understand what is harm and what is civil liability, what is the damage. Then if damage it's about the regulation that it's about fundamental right, where harm is not an issue. How do we deal with this? That's my question, comment. And the other question is easier. It's for the first speaker, and I really liked your presentation. It was very descriptive, and what I would really love to see are 27 presentations like this with all the member states, like explaining the situation, what do we know about damage in all the member states? So is there a comparative dimension in your research? Do you also look beyond the Netherlands, or do you have 26 friends that are doing the same thing? Thank you.
Excellent questions. Claudia.
Yeah. So thank you for this, Gloria, because it gives me an opportunity to clarify something. I've actually, when I mentioned societal harm, I'm actually more interested in just a violation of a fundamental right. And of course, we don't typically think of that as a harm. I think with the risk-based approach, this has changed somewhat, as the Article 29 Working Party also mentions societal harms. But in thinking about this in relation to tort law, of course, we must keep in mind that there is this distinction. We have violations of fundamental rights, and then we also have individual harms, or harms that can be felt at an individual level. But yeah, thank you.
Okay, great. Tim.
What I do know, to answer your question, if I look also to the other countries, I think this is your question. What I do know is that this question of the absence of legally relevant damage also is taking place in other countries such as Belgium, Germany, France, Spain, I suppose as well. But it also is a big problem in the United States in the whole standing doctrine. And an important requirement of the standing doctrine is that there must be an injury in fact. And the question also there is, we see there's a violation of a statute, but again, what's the harm? So I think this problem also is also occurring in other countries. But to get back to your question, I think that in my opinion, I think there's a huge role for the European Court of Justice to interpret the notion of damage. If you look to Article 146, I think they have the duty to interpret the notion of damage. I'm quite optimistic that they will do it. But as said before, I'm not sure how they will fill in this notion of damage. And I think this notion of damage will take prevalence over the national regimes because simply it's needed to have an effective enforcement of data protection rules throughout the Union. Does it answer your question? Yeah.
Yes, maybe I can add. So you're basically arguing for, or even describing that the court will have to provide an autonomous EU interpretation of the term damage. Do you have examples of that in other branches of law that reflect on private law? Can you give us an example?
Yeah, there's one clear example in the Leitner case. It was 20 years ago, and then the European Court of Justice had to interpret the notion of damage with regard to people who go on a holiday and there goes something wrong on their holiday, or they have a loss of enjoyment of their holiday, and then the European Court of Justice said, this loss of enjoyment, we consider this as immaterial damage. And while saying this, they broadened the notion of immaterial harm. And in analogy, we could say that I think that the European Court of Justice can do the same with data protection, broaden the notion of damage to fulfill the needs of the customer in the Leitner case, and in analogy to the data subject.
So could you be more precise? Because I think that is the question of this panel.
Yeah.
How you want to broaden that scope? So
that's a very good question, and that's what I'm researching in my PhD. And I'm not sure, but I think legal certainty and trust in the data control is a very important aspect.
Let's put it a bit sharper. Would you accept? This refers to a question that Gloria asked Claudia. Would you accept that at some point the violation of a fundamental right is in itself under private law considered as a harm? Would you accept that as a private law lawyer?
Yeah, I would accept that. Yeah, with regard to my presentation, I think I mentioned integrity damage, and I think this is merely the same. There must be a severe violation of a fundamental right. But then the next question is, what do you do with less severe or with minor violations? Do you let them unpunished? Well, that's still a problem then.
Yeah, and now you're saying minor or major violation, or do you mean a violation that has minor or major repercussions? So if somebody is processing my name and address, that's a violation. It's a violation, but in what sense is it minor?
Yeah, I think you have to take into account both criteria: the severity of the violation and the severity of the consequences.
Is there another question in the audience? Yeah. Can you take the floor at the?
Hi, I'm Aviva Groot from Tilburg University. I have a question for Pieter. I was wondering, because the idea of holding controllers liable is that a data subject has a way of knowing who this controller is. If you start holding little third parties responsible as well, the risk might spread. It might be hard for data subjects to know who this person is, and this company also would not have the financial strength to come up for these damages. So wouldn't that increase the risk?
I would not argue that third parties should be held liable instead of the controller. I think they should be held responsible in addition to the controller. So it would only increase the options of the data subject in that respect. So I don't think that it would increase the risk. I would only argue that the data subject should have more options. And why are more options important? Well, you gave an interesting example of the big controller and the little third party. But what if it's reversed? If it's a small controller with 5 employees and a big software provider, a big security firm that messes up, then the small controller might not have the financial means to compensate the data subject, and the third party would have those means. So this is a clear example where having extra options is a good thing. And finally, the controller might, it is a point of contention whether the controller is liable if the mistake has been made by the third party. Article 82.3 stimulates that if a controller can show that it is not in any way responsible for the event giving rise to the damage, it is not liable. So then we have to ask ourselves the question, what if a small controller, like the one I'm talking about, that should not reinvent the wheel, it should not think about its own security and then implement it. It should rely, but also control, but also monitor trusted third parties with a good reputation. And those trusted third parties, that firewall that is used everywhere, that security specialist that is certified in every way imaginable, what can we reasonably expect from the controller? Can we expect that he does more than that? I would say no, so there will not be any fault on the case of the controller. But then the next question is, would that be an excuse in the sense of 82.3 of the GDPR? Would that mean that he's not responsible for the event giving rise to damage? That is a point of contention, and that is one more reason that more options for the data subjects is something that is good. Not if the third party does not possess personal data. I wouldn't say so.
Would you argue then for several liability if the controller is also cannot disprove his fault?
I think that they should both be held. That they should both be held liable for the full amount of damage.
Okay. Yeah. So in that sense, several liability. Question. Yes, please.
Andrea Corti from the Technisches Bürgernetzwerk, Austria. I waited until the very last moment because I don't have a mandate from my board to represent animal rights, but since clearly represent the big white elephant in this room, I guess I'll have to do. And that big elephant is the NGO sector and the power that the GDPR specifically assigns to NGOs to help data subjects support and defend the rights. So my first question to you is, how do you see that in an evolutionary perspective in making it easier, smoother, and having less friction for data subjects to protect their rights both before regulators and arguably before courts? The second point is we act as processor because we provide IT infrastructure services to other NGOs. So actually, when I read your article, the fact that an IT security firm, because it does not process personal data allegedly, is not under GDPR, I have some issues with that. Of course, you know, first of all, you do pen testing, you do access personal data. It's practically impossible not to. And you process it, and you have to process it extensively. That's the first point. The second point, there is actually a way that's being implemented by companies all over Europe of extending the scope of the GDPR compliance. And quite simply, they do that by appointing in the written contract that they stipulate with IT security providers that they are processors. It's as simple as that. And I think that any court would uphold that. And I can guarantee you that the DPOs of data controllers are mandating de facto their boards to approve such contracts and to approve them only if they're stipulated and drafted that way. Thank you.
Okay, so you're asking the question, two questions. The second question is clearly to Pieter. And the first question you are asking the whole panel? Yes. Okay, let's start with Tim.
Can you, yeah.
It's about the issue of collective action and whether you can sketch what are the possibilities in terms of what problems it may resolve.
The thing is that we don't know what the problems will be, but I can give an indication. As I said during my presentation, I think that if we look to material damage, for example, the material damage per person will be that low that it wouldn't be rational for a data subject to start a civil procedure. So in this way, a collective action will be an outcome to bundle forces.
Is there a right in the regulation for collective action concerning damages?
Yeah, in Article 80, Section 2 states that there can be, data subject can mandate it, but it must be, this option must be provided by member state law. And if I remember correctly, most member states do not have implemented this option. What I do know is that the Netherlands will probably provide this option. So it will be very interesting to see what this means for class actions that are cross-border, and maybe that certain action groups want to move to the Netherlands. So that would be very interesting.
Yes, and anyway, all the other actions that are in Articles 78, 79, etc., they can all be mandated based on the GDPR directly. They don't have to wait for national law. It's only with respect to the damages that it's left to the member states. But enforcement actions, injunction, all goes under the GDPR. Can be collectivized. Claudia, I'm coming back to you.
Yeah, thanks. I do think the NGOs can solve a gap, let's say, in the framework, because I mentioned that, well, if individual harm is felt only at the individual level, and the definition of societal harm is that it is not felt at the individual level, but it's a collective affair that pertains to all data subjects, then of course representation is the solution. We could have a body representing all those data subjects and acting on its behalf, and NGOs could perhaps fill that gap in the conceptual framework, but are NGOs real representatives of data subjects? I mean, they'd have to be a pretty impressive NGO to be able to claim that, I'd say. So.
Okay, thank you. Valerie, would you like to respond to the NGO question?
The collective issue, in essence, it's about the thresholds again. So from my perspective, I'm going to come at it in terms of, is it deterrent? Will it be deterrent? And as yet, we don't know whether it could act as a deterrent. I always go for the carrot. That's what I want rather than the stick in terms of where I see organizations in the future. But the NGO element is a place we need to watch. I think going forward, collective actions. If we take TalkTalk, for instance, their breach, 167,000 records were breached, each belonging to an individual. If those individuals had a representative group who could operate on their behalf, we might see a deterrent for organizations coming out of some kind of action like that. But as yet, it's unclear what that landscape might look like. That's my view.
Yeah, if I remember well, I'm trying to quickly check. The GDPR does give everybody a right to mandate her own damage. That's clear. That's not waiting for national law. But an NGO that is representing in its statutes these kinds of values can on its own, without any mandate, start injunction actions, etc. The only thing it cannot do is file for damages, except if national law allows. This is to be precise. Any more questions? No, sorry, we had the second question. Pieter, please.
Yes. So IT security firms might process personal data while they are doing their job. But we have to ask, does this solve our problem? So your example was a pen test. The IT security firms might process personal data when doing the pen test. But that doesn't affect my issue at all. That only means that they have to securely process the personal data while doing the pen test. That does not make them wholly responsible for the personal data at the controller in a general sense or afterwards. The GDPR assigns responsibility on a processing operation basis. So yes, the pen test has to be secure. They do it securely, but then they do not implement security measures for the company. The company uses those security measures. The company is processing the personal data, not the security firm. So this only slightly lessens the problem. Even if they have some responsibilities under the GDPR, they do not have a broad obligation to secure the personal data of the controller. Secondly, the DPA might stipulate in a contract that might say that the controllers are obligated to make them a processor in the contract. Well, maybe, but one problem that I'm hearing everywhere is that controllers, especially small controllers, when the processors are big or when the other parties are big, those other parties will not cooperate with forming a certain contract. And even if you, and like I said, even if you say you are processors, in what sense, in what processing operation, for what data? I don't think relying on a contract is a secure way to make sure that the data subjects can hold responsible these third parties.
Okay, thank you very much. Last question. Yes, please.
Hi, my name is Katarzyna Syska, and I'm a practicing lawyer from Warsaw, Poland. So I'm very much interested in the private liability questions. And my question is about the relationship between the right to compensation, so Article 82 of the GDPR, and the right to an effective judicial remedy against a controller or a processor, so Article 79 of the GDPR. Do you think these two rights can be combined in one proceedings, or, well, somehow are they interdependent?
Our private law specialists will answer these questions.
I don't think I fully understand your question. Your question was whether Article 82, the right of compensation, and the right of an effective judicial remedy could be combined?
Well, yes. For instance, in the same proceedings, so I asked the court to enforce my right, let's say, to erasure, because a company denied me the right to erasure, and then at the same time to award me compensation because the company, the controller, denied my right. Yeah,
that could be a viable option, but to be honest, we haven't seen, at least in Dutch case law or in European case law with regard to data protection, such examples. So I'm waiting for the European Court of Justice or Dutch courts to answer these kind of questions. But yes, it would be a viable option.
Pieter wants to add?
Very short, yes, but this would not solve the problem of damages that has already occurred and violations that have already been made. So you would still get the problem of what is the damage. You can erase someone's information, but if it has already been abused, like in the Ashley Madison case, that only solves a very small part of the problem.
Okay, thank you very much. I think this has been a very interesting panel. I learned a lot. It's very interesting that there are maybe less people than in some of the other places, but I think in a couple of years that's going to be very different, because I think this is very important stuff. Okay, thank you very much to everybody of the panel and to the public, and have a great coffee.